Good morning, everyone. Fox 10 investigator Justin Lum here. We are covering Lori Vallow Daybell's pre-trial hearing about to start in just moments. First of all, I want to introduce you guys to our special projects executive producer, George Obi. We have been covering this saga, Obi, for 5 years now, a little more than 5 years now. And here we are, just weeks away from jury selection, and of course the doomsday mom representing herself in her own case. And we're going to button down some things in this next hearing that should last about half hour or so. So thank you guys all for joining us. George, it's basically pre-season for this trial, one of two.
It's kind of ironic that this is the case that kind of started this whole saga, and here we are 6 years later. So this will finally come to a head as this first of many streams for us in the coming weeks.
Yeah, so pre-trial is important because you're talking about evidence that's still being gone through. I mean, 22 terabytes of evidence we know in this case alone here in Arizona. And we've gotten a roadmap basically because of Lori Vallow Daybell's Idaho trial in 2023, where she was convicted of killing her children, J.J. Vallow and Tylee Ryan, and in the murder conspiracy in the death of Tammy Daybell, Chad Daybell's first wife. So there's a lot there. You've been following this, you know the people we're talking about, but this is going to be some key issues brought up today because of this hearing that's beginning right now, and we'll take you there live, streaming.
001704.
Your Honor, for the record, this Trini K on behalf of the state, and for the record, the next of kin and the victim in the 2022 matter are appearing virtually.
All right.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
Go ahead and announce.
Lori Daybell.
All right, thank you. My courtroom assistant said there's some issue with advisory counsel at the table.
Yeah, I apologize, Your Honor. I didn't think about the logistics, so I'll just let Ms. Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings. So that you can have, if you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
Appreciate it. Thank you, Your Honor.
All right. I just received word literally 2 minutes ago that we will be using Judge Kemp's courtroom, and we can use it for the entire first trial, which is in the South Court Tower, which will give us more space as needed. Have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it. That's my proposed questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors in follow-up. So this is not limiting what would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses in a little more detail, especially as it pertains to how people perceive officer testimony, and some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues, such as pretrial publicity or opinions people may have had, or exposure to the case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member's been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ. which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it, about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I forgot I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we,
Defense filed that on the 12th of March.
okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay. All right. Let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. Continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right, I'm gonna make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. All right, so I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And, well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own Cellbrite or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So you're, well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that this is the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up.
Well,
But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial, you want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the, let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if
Hard drive.
hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dworkin says, that
Well,
would put
it could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January, and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your Honor, the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting, my paralegal
copies
is
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said, next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told to you secondhand or showed to you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you want me to, I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or Or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right, be at recess.
All right. If you're just joining us, you are watching the Lori Vallow Daybell trial coverage. That was the pretrial conference. Fox 10 investigator Justin Lum here with Special Projects EP George Obi. Where do we start? I mean, first off, we just left off Lori Vallow talking about her husband, Charles Vallow. We know that is her former husband that she's accused of conspiring to kill.
Right.
Her late brother, Alex Cox, shot him in their home, and she wants the phone. She wants a lot of evidence. So what we're getting here is that she doesn't seem very prepared to represent herself if her expert witness doesn't even have the devices. And here we are just about 2 weeks away from trial.
It is kind of shocking that a case like this, that she's had this much time, she's requesting a speedy trial. We know from you and I both know how much evidence involved in this case.
Mm-hmm.
And for any investigator working on their own to try and delve through all of that in this short amount of time, almost impossible.
22 terabytes of evidence on a hard drive that they are for certain still going through. But first off, the jury questionnaire, very important because we've been through this before in Idaho twice with Chad and Lori in those trials. Pre-trial publicity. This has been going on for 5 years now, and prosecutor Trina Kay just said that the Idaho case specifically has been all over the media. It's been covered nationally, internationally, and that they plan to mention J.J. Vallow and Tylee Ryan in that questionnaire and Lori Vallow Daybell's name so people can be truthful and say if they know anything about the case. But the judge was also considering, well, how do we, not put in that she's been convicted in another state? And you're not going to get away from that. She's a convicted child killer.
Mm-hmm. I think that, unfortunately in this day and age, it's very difficult to, hide those things. We've seen in other high profile cases, at least in this county, that the possibility of finding a jury a jury of your peers who may not have followed this case,
Mhm.
I think you have a better chance in a county like this than say a small town like Boise, Idaho, where that was the story of the year.
Yeah.
But again, it's going to be interesting because as we'll talk about later, we're going to have two trials back to back, and so the media coverage on this trial will certainly impact a jury potentially for the next trial, which is going to happen immediately after this one.
Especially when we cover this trial for Charles Vallows every day.
Yeah.
And then it's going to be the one for Brandon Boudreaux, her ex-nephew-in-law, who was shot at in his Gilbert driveway. And he fortunately survived. And Trina Kay, the prosecutor, says she doesn't expect them to find a jury in the first week. The judge is hoping for opening statements to begin on April 7th and get through the jury questionnaires in person voir dire April 1st through April 3rd. And they'll have about 200 jurors first off fill out this questionnaire. So we have about 6 weeks slated out. This was interesting that Lori Vallow Daybell called out her former defense and said that they basically said, here's the 22 terabytes. There's no file or anything else that they provided them with. They don't answer calls or emails. And she's basically throwing them under the bus, saying they're not helping us. So we want to show you that exchange as far as what she was explaining. Glenn, if we could take that soundbite, it's about a minute's worth in court earlier.
Closed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that.
For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Okay, so you heard a little bit there from that exchange in the courtroom. So let's talk about who is Lonnie Dworkin. He is the expert witness here that is basically helping Lori Vallow Daybell, and he was just approved recently to be her expert witness. And the judge basically tells her in court that you've had a lot of time to make copies of these 22 terabytes, and even though he wasn't approved until now, like you're gonna have to transfer all that evidence to him, and it doesn't look like you're ready because he doesn't even have the devices. So that's where we're at.
Yeah, and I as somebody pointed out in the chat earlier, the same expert here was also testified in the Jodi Arias trial. It is interesting the approach she's going to take with forensic evidence. Again, we've talked about how much evidence there is. The video, you and I have tried to figure out exactly what she's talking about.
The YouTube video.
Exactly, and where this is coming from, why she feels it's so important that she has this video and how that pertains to her case. But again, depending on which angle she's going to take, it's a very interesting position that he's in to try and decipher all of this information and then again get out of it what she wants him to get out of it. Because again, we still don't know exactly what video she's referencing.
Context is key, and that's why it's so great we have the time to really chew on this right here in Studio 3. She's talking about a Gilbert police video. Obviously, this is a Chandler investigation into the murder of Charles Vallow. But as we know, Charles Vallow, her husband, pleaded with Gilbert police in January 2019 to get her mental help. And at some point during that span of about 24 hours, she goes into the Gilbert Police Department because she says Charles has taken her purse, and he's trying to basically get her like in front of someone. You know, he's doing whatever he can because this is just after she had allegedly threatened him threatened to murder him, talked about being a god, and he's thinking that she's having a true mental breakdown. So she's in Gilbert Police, and we have the body camera footage that's been posted, for a long time. We have those records, but we never seen any other video that she's alluding to some sort of interrogation room or some aerial view that she brought up in the last hearing. So we'll see what happens with that. The judge says he will order the former defense team to basically turn over a file, an actual file that they should have. Now, also witnesses that have been noticed by the defense. They include family members, but they also include our friend Nate Eaton with East Idaho News. And the question is, why does she want Nate Eaton on this list? The prosecutor is a little bit confused. Luckily, I'm not on the list. I don't know what's going to happen with that, but obviously that's another interesting note there.
Yeah, it's interesting because, first of all, and I think the elephant in the room is it's rare, in at least in a high-profile case like this, for a defendant to represent themselves. So, I think the rules around a trial, they change a little bit when you have someone who is clearly not an attorney, has never tried a case, and now, this individual, Lori, is trying to defend herself in court. So no matter who she calls, it'll be interesting to see how they teach her to approach each witness, and what she's trying to get out of them to help her defense. I think that some of the witnesses will see standard issue prosecutor's defense. A lot of the questions will be the same. I am curious to see how she's going to approach Nate, what the line of questioning will be, what the relevance is for his role in all of this, because Nate only started. I mean, Nate's involvement came after all of this, right? We're talking about a case 2019 that kind of set the wheels in motion for this entire
right
saga.
at the start of the year.
Right. And so Nate came in much later than some of us did. So I am curious to see what she's going to ask him, and what the judge allows her to either get out of him or some of these other witnesses. Because again, as I said, you've got an individual who clearly is new to all of this. It looks like she's got some support, but again, you have to be very careful, especially in the eyes of a jury, how you approach every witness.
Yeah.
And the questions you ask them.
We started covering this in December 2019. So did East Idaho News, who she's noticing as a witness. But obviously there was so much to uncover from the Chandler case, and then Nate's involvement comes in as he confronts her in Hawaii. We've all seen that video of confronting her and Chad Daybell as they're walking back to their hotel from the beach, asking, "Where are your kids?" Now, here's the big question. Will she testify? And that was brought up today. If you want to take the witness stand on your behalf, you're going to have to write out your own questions since you're representing yourself, and your advisory counsel will ask those questions. Does Lori Vallow Daybell put herself in the hot seat where she will be cross-examined for the first time? And I'm sure everyone's been waiting to see.
Well, and you and I have noticed, we've seen her on body camera. We've seen her in interrogation rooms. She obviously chose not to testify or speak on her behalf in her previous trials. Again, very rare for a defendant to represent themselves, even more rare for them to put themselves on the stand in their own defense. And again, I don't think I've ever seen this where they've written out questions for themselves. I am curious to see, again, does she do it? And what questions are there going to be? And then, of course, again, there's the cross-examination phase, which, we have talked about too. There aren't many people that have gotten the opportunity to ask her questions about any of this. In fact, it's only happened a few times.
Exactly.
So this will be, I think, if this happens, this will be a unique window, or look into who she is and what she is claiming in her defense in this case.
This will be huge because people want real answers, and you can't really escape them when they're coming from a prosecutor on the other side. When it comes to cross-examination in the first trial in Idaho, she was quiet. We didn't hear one thing from her, and it was clear she was not happy with her defense. There was not one witness called. She didn't testify. The only real, I guess you could sort of call it a testimony that they somehow brought in as evidence was from an audio recording where she talked about her love for Jesus Christ and her religion, and her defense basically painted her as she's just this super spiritual religious lady that was influenced by Chad Daybell. Throw Chad Daybell on the bus. Her sentencing, she doubles down. She says that, no murders happened to her children. Tammy Daybell wasn't murdered. and now she's done a Dateline interview where you didn't get a lot from that as far as like, did you do this to your children? Did you harm Charles Vallow? I mean, so I don't know if she would be, I don't know if that'd be a good move to put her own self on the stand.
Well, and the judge made it a point to, point out the fact that if she chooses to do this, it's going to be nearly impossible for the jury not to hear about what happened to JJ and Tylee in some fashion. And again, there was a lot of talk at the beginning of all of this, whether, they wanted to kind of separate those cases. And you can understand why. But the judge was very poignant this morning to say, look, there is a real possibility that if you do this, you're opening that door for the jury to be exposed, if they haven't already been exposed to that they could be, exposed to those cases.
It will be mentioned they cannot escape that the conviction happened, and they won't get into all the evidence. But just like in the Idaho trial, they opened that door for all the Arizona evidence to come in to provide a context to the motivations that happened for the triple murders in Idaho. So we got a sample size and got to see a lot of the evidence via Charles Vallow's text messages, his emails in that case. So we're going to see it here. And we're talking about 22 terabytes of evidence. I mean, the text messages, you read some bizarre messages between Lori Vallow Daybell and her then boyfriend, Chad Daybell, into her inner circle, talking about how Charles Vallow is somebody named Ned Schneider or Hiplos, and how they're going to work on him and do these energy, I don't even know what you call it, but she had an inner circle there, including witnesses that testified, Zulema Pastanes, Melanie Gibb. I would assume that they'd be on the witness list for the state in this case as well, to talk about the motivations and identifying Charles Vallow as this dark spirit and zombie. And there's text messages on the life insurance policy. It is all there, and we have that.
You have to, and I think, again, you have to establish a motive. And as we saw in the Idaho trials, very Arizona heavy, or, we saw how much of the Arizona cases were brought up there, the investigators, but also how religion played a role. We explained that in our coverage in the beginning. And I think for the state, that's important to provide some sort of motive for that. And again, if you watch the body camera video of Charles, he alludes to a lot of this, but for him, his method of thinking was like, look, this is a mental illness, or this is, this is a concern for not only the children, but himself. And in the end, I think the state, it's like the elephant in the room in this case, that she was clearly driven by her religion. She talked about it a lot in the Dateline interview. I'm almost guessing she's going to talk a lot about that, or at least try to.
She believes she'll be exonerated in everything, and that, there were no crimes that were committed. But she's going to have to go with the self-defense theory, because that's how this whole case started, and why you could argue that Chandler PD didn't do anything in the beginning, and she was allowed, her and Alex, to move to Idaho, and then just within a couple weeks murders her kids. The self-defense theory that Alex Cox was hit in the back of the head with a baseball bat, a metal baseball bat, by a former baseball player in Charles Vallow after a fight. And he had been in that home for maybe 15 minutes. He gets there, Chandler, 7:35 to pick up JJ, and this all goes down, and he's shot twice. And what does Lori Vallow Daybell do? We all know the story. Burger King, Walgreens takes JJ to school in Charles's rental car. There's surveillance video of all that.
Exactly. All documented. The body camera video. We already know that she wants Tylee's, interview on that to be excluded. Like, all of this has been documented. It's rare when you have a case like this where you have, again, this much video evidence. We know the timeline. We know where she was. We know where the kids were. Again, all of it's going to come into play. But I think that for someone like Lori, any lawyer, but Lori specifically, this is going to be interesting to see how they approach it, and what she objects to, because again, she may try and object to a lot of this, and it'd be interesting to see, how the judge handles a lot of that.
What has she learned while behind bars studying case law? I mean, for any veteran criminal defense attorney, I think this is a tough case to defend in just murder conspiracy. First degree murder, I don't know, she obviously didn't pull the trigger here, but she did not call 911, and we know it took Alex Cox 43 minutes to call 911. There was no CPR done, and you have all the text messages on a possible motive that, prosecutors are going to lay out, and how they basically knew things were going to come to a head that day. Just so much had gone down. So that's why prosecutors believe this is going to take 6 weeks. They even said that it would be shorter if they were probably dealing with the criminal defense attorney, but she's not. So we're going to see some holdups as she tries to defend herself. And let's talk about trial number 2 after that. We've got a whole season. We're going into summer
Yes.
with this saga.
Right, and the judge alluded to that to the end at the end of the proceeding today. Gave timelines of when they would like to start jury selection for the second trial.
May 30th.
Right.
Yeah.
They did point out the fact that he wants a much larger pool for the second trial. Understandable, because again, you will have the coverage of the first trial so close to this one. But he also said that he would like to have all of this wrapped up by July 4th. A valiant effort, and we'll see if that comes to fruition. But it is very unique circumstance when you have a defendant like this, 2 trials right back to back.
Yeah, well, she
Same
wants
county.
them done, even though it appears she doesn't have her own expert witness equipped with what he needs to analyze.
Yeah.
So we're about to wrap up in a little bit, but if you want to take a look and see if there are any questions from the chat box. But just to explain to you guys, as you saw, I was tweeting about the coverage in the courtroom. I did not mean to say live, but we'll be streaming it to you as it's happening here. So it's like we're in 2 universes. Just want to be transparent. There's a 30-minute delay, and that's all on public record, ordered by the court that we're not supposed to distribute until 30 minutes after. Now that we're doing that, we'll be talking about this every day in trial as after the hearing, after the proceedings begin, and we'll be just going through trial 1 and trial 2, and it's going to be a marathon, so that we want you here with us watching. Yeah.
We do. We've got a few guests that will join us. Again, we're not legal experts, but we would like to think we're an expert on this case and this saga. There's going to be a lot to go through. Again, an ordinary defense case would be great, but when you have a defendant like this representing herself, I think it adds a new twist, and I think it could be beneficial to a lot of people watching to see how this plays out, and especially for a lot of the people who are on this stream who have followed this case like we have for the last 6 years. It's going to be interesting, and again, we're going to be here through the entire thing, so we appreciate everyone joining us today.
Yeah, and I love the comments here, even though they're not necessarily questions, but you guys know what you're talking about here, the text messages where, Lori Vallow Daybell tells her inner circle, we got rid of Ned, or we got rid of the dark spirit that she says is Charles Vallow. And so all of this evidence is out there. Another good point, the judge is rotating out of this division in June. So what's that going to look like? Is he only going to preside over this trial? And this judge has been very fair,
Yeah.
I believe. And we have a camera in the courtroom, and we've been able to be there for everything. And he knows that this is a high-profile case, and he understands she has the right to represent herself. And even sometimes he's laying out alternatives for her and kind of like, well, if you do this, this is what's going to happen. Do you want to start this trial? You're pressing for a speedy trial. So for any judge that might step into the next one, this is a lot. It's a lot.
It is, and we've already seen her demeanor in the last couple of weeks in these hearings. I can only imagine that's going to be magnified when the trial starts.
Okay, so before we go, follow me on X at JLumFox10. I will be posting about trial every day as it begins. Jury selection will not have camera coverage because of reasons that we've explained and the judge has explained for privacy reasons on these potential jurors. And then 30 minutes after things begin, you join us here. So subscribe to our YouTube channel. Make sure you hit the bell so you get notifications, and be standing by just like you were today. We appreciate you for joining us for coverage of the Lori Vallow Daybell saga.